One of the things that folks who work on animals tend to do is try to remind folks that we are animals, right? And that's a really hard thing sometimes for people to remember, but it's an interesting lens shift that's useful. And animal lawyers focus on how we can speak for animals, but I think it's also useful for us to think about how we speak as animals.
I'll give sort of like a warning up front. There's not a lot to say in terms of animal rights policy in federal legislation. When the ESA was passed in 1973, it was passed almost unanimously and was really a bipartisan issue. And now it faces really constant attacks, primarily by congressional Republicans. But I also promised that there would be bright spots. And I think what's actually interesting about animal welfare is that it can be one of those rare issues that tend to be bipartisan. And I am talking about specific species in specific contexts and within the right scope. But if you hit the sweet spot there are some bipartisan legislative achievements. One thing that's really interesting is Indigenous knowledge is becoming more widely embraced and elevated and incorporated into decision-making. The wildlife corridors and habitat connectivity work that's happening when the administration put out the America the Beautiful initiative, which is an effort to conserve and protect 30% of US lands and waters by 2030. Wildlife corridors and habitat connectivity was one of the first 6 main pillars. Like I talked about earlier, getting sort of the standalone shiny animal rights bill is unlikely. But so then it's time to look at sort of like other ways, right, to get creative. And there are opportunities in must-pass legislation, right? So like every year we pass the NDAA, which is how we got the shark fin ban through. The farm bill, right? We got to do that every 5 years. And then appropriations packages, we theoretically fund the government every September. You see like opportunities, you got to grab them. It can feel like a really uphill battle, like there's a lot of work to do, and there is. But when we rally together and leverage our voices and leverage our power, it's, can be really, really meaningful.
I wanted to kind of take up where Kenzie left off and speak a little bit more about the state level. The states, have common law, they have police power, they have these more nuisance, these kind of more amorphous things that I feel like there is more, there's some potential for kind of inserting some of the ideas, rights of nature, rights of animals that we've been talking about into those. A couple of years ago in New York, we brought a habeas corpus case on behalf of an elephant named Happy in the Bronx Zoo, who's been alone for 20 years. And the goal was really to take this massive science that we now have that speaks to them being, their complex cognitive abilities, analytical abilities. It really comes back to this notion of, can an animal have any rights? Can they be a person? This was really the first time that this kind of issue was presented to an American court. And so you might expect that it would be tossed out kind of immediately and, might not get very far. But actually, Happy's case got to the highest state court in New York. They actually ruled 5-2, perhaps not so surprisingly, that Happy the elephant is not a person entitled to habeas corpus or to any other rights. It's nonetheless really significant that 2 judges saw fit to write very detailed dissenting opinions. When legislators see judges write these kind of things, like that will help the process of, encouraging legislators to start to, write rights for animals into law. And what you see here real briefly is something we're working on at the Earth Law Center. The city of Bainbridge, it's a declaration, a proclamation supporting the rights of the southern resident orcas. They speak to their cultural, spiritual, economic significance, the fact that indigenous peoples, the Lummi Nation, see them as, family members, right? They're not binding. They are definitely symbolic, but the goal, and I think what is beginning to happen, is you get more and more of these, and it adds up, and you can take that to the state legislature and then use that to have an actual law passed. And once that happens, in my opinion, things begin to get really interesting, because you no longer have folks like me coming in and saying, hey, judge, please do this. You have, an elected body of representatives who have then, passed a law like this, which then allows folks like us to perhaps, really begin to push the envelope and see a day when judges give at least the same amount of care and interest to the legal rights of non-human animals the way that they do currently to corporations.
a very important case in Latin America and Ecuador. It was the first case where the rights of nature and animal rights came together to recognize that an individual animal has constitutional rights. In Ecuador, the Constitutional Court has the power of selecting cases to develop binding jurisprudence. The court asked if animals can be considered as subjects of rights, what's the scope of the writ of habeas corpus, and if non-human animals can be considered subjects of rights protected by the rights of nature. And so we answered that animals are subjects of rights, that the habeas corpus can be appropriate for animals, and that animals are subjects of rights protected by the rights of nature. The problem was also that the rights of nature as environmental law had only focused on animals from a species level and hadn't defended that individual animals could be protected by the rights of nature. We argued that species are made up of individuals, and we gave the court cases on, for example, how in certain situations there are so many individuals left that if you hunt one or kill one animal, you're really directly affecting that survival of the species. Even in cases when the animal does not belong to an endangered species, there are also arguments to protect the individuals. When we are hunting, killing animals, the death of that individual or poaching an individual and taking that individual away from his or her community produces a lot of negative effects to the community. So, for example, the reproduction rate is affected by the situation. Then, as we know, there's a lot of research on grief on animals. So when an animal dies, for example, a mother loses her baby or a baby loses her mother, that animal suffers from a lot of stress related to grief. And the other argument we gave is that if the court decided that individual animals are not protected by the rights of nature in Ecuador, then how many animals would have to be killed to trigger the rights of nature? So what, would the court have to write a huge catalog that you could kill 2 jaguars, but 10 woolly monkeys, but I don't know, 5 parrots? So it's an impossible question, and hunters could easily bypass the rights of nature by just killing less animals than those established by the court. It was very exciting because the court ended up citing our brief extensively throughout the ruling. It voted 7 against 2 judges, and the court recognized that animals are subjects of rights, that individual animals are protected by the rights of nature, and that the habeas corpus can be appropriate for an animal depending on the circumstances of the case.